NT WorkSafe is a division under the Department of Attorney General and Justice and have multiple roles in the administration of various pieces of legislation, including the return to work for workers' rehabilitation and compensation, which I'm here to talk to you all about today. The Northern Territory has been relatively fortunate with coronavirus, with 32 confirmed cases with all people affected making a full recovery and having no community transfer. However, there are still Territory businesses who are affected by COVID-19, and given the uncertainty of this virus, it is not a time to become complacent. We are hoping that today's presentation will provide you with knowledge and understanding on workers' compensation and to ensure obligations are met. So for those watching online, I kindly ask that you mute your microphones and turn off the cameras. There will be time allocated for Q&As after the presentation. So during the presentation, for those online, if you do have any questions, you can select your chat icon, which looks like a little notepad, and you'll be able to bring up the sidebar and just pop your questions in there, which we'll answer. And for those at today's presentation at the museum, we'll do those questions as well. So NT WorkSafe, what does the Rehabilitation and Compensation team do? So NT WorkSafe's Rehabilitation and Compensation team provides a service to all stakeholders. We give information on rights, obligations and processes that are provided for in the legislation. There is a team of 8 people, including myself, that administers the return to work legislation, and we are located in Darwin. We do not manage injured workers' claims. These are managed by the approved insurers and self-insurers in the Northern Territory. In the last 12 months, the Rehabilitation and Compensation team have responded to approximately 11,500 emails and 6.5 phone calls from all stakeholders. When we refer to stakeholders, we are referring to all persons that may be involved in the claims process. This includes the injured worker, the employer, the insurer, and the treating medical doctor, but it can also include allied health professionals and vocational rehabilitation providers, including lawyers, unions, and family and friends. Many of the injured workers who contact us are distressed and often do not understand the rehabilitation and compensation system, and we recognise how critical it is to educate all stakeholders, especially during these times with the effects of the coronavirus. The Return to Work Act defines an injury in relation to a worker as a physical or mental injury arising out of or in the course of employment includes a disease. A virus like COVID-19 is likely to be considered under the diseases provisions of the Act. For a disease to be covered, it must arise out of or in the course of a worker's employment. NT WorkSafe does not make liability decisions on claims. This is done by the approved insurers and self-insurers in the Northern Territory. For liability to be accepted, an insurer would need to be satisfied that the employment was the real, proximate or effective cause of the worker contracting the virus. For viruses, though, it can be difficult to accurately determine the exact time and place of contraction. As a result, it may be difficult to determine that employment was the real, proximate or effective cause of contracting the virus. However, where a worker's employment is at greater risk of contracting the virus, the significant contribution test may be easier to meet. An example of this is if employment involves travel to an area with a known viral outbreak, or activities that include engagement or interaction with people who have contracted the virus. An example of this would be your healthcare workers. Each claim would need to be considered on its individual merits, taking into account individual circumstances and evidence. When deciding whether to accept a workers' compensation claim, which includes a claim relating to the diagnosis of COVID, insurers will apply specific criteria from the Return to Work Act. So criteria will include, but is not limited to, the claim was made within the required time frame. So the Act states a worker is to lodge a workers' compensation claim within 6 months after the occurrence of the injury, or in the case of a disease, when the incapacity arising from the disease occurred. The worker was in fact a worker. There is a definition of worker, but also the ATO tool will assist in regards to that definition as well. An injury or disease has occurred. The exposure to COVID-19 occurred in a work environment. That the worker's employment was a real proximate or effective cause of the worker contracting the virus. Insurers will rely on information from you as a worker, your employer, and the medical practitioner when using the criteria to determine whether the claim will be accepted. Please note that provisions exist under the Act to enable a worker to appeal a claim decision made by the insurer. This is the disputes resolution section of the Act that covers internal review by the insurer on a decision and the mediation process. It should also be noted that management action taken on reasonable grounds and in a reasonable manner or by or behalf of a worker's employer is not considered to be a mental injury for the purposes of the Act. Management action interpreted under the Act in relation to a worker means any action taken by the employer in the management of the worker's employment or behaviour at the workplace. The Act outlines the scenarios of management action. Examples of management action that could relate to COVID-19 are requesting all or some of the staff work from home, relocating staff around the office or even in different locations, ensuring 1.5 metre distancing, conducting meetings through online portals, or staying home if feeling unwell. Employers following mandated instructions as directed by the Chief Health Officer by the way of the COVID-19 safety plan checklist could be viewed as reasonable management action if a claim was to be lodged under these circumstances. This is based case by case, with the insurer taking into consideration all relevant information provided to them at the time a decision is made. In the early stages of an outbreak, where there are limited numbers of known infections, there is potential to track exposure. However, as the virus becomes more prevalent within communities, it will be difficult to identify where a person was exposed to the virus, and that could occur out of or in the course of a worker's employment, as within the cold or the flu. Self-isolation does not mean a person is suffering from an injury or a disease. The Act requires a worker to undertake reasonable treatment and training or assessment. However, insurers and self-insurers have strong contingency plans in place that include making alternate arrangements to assist injured workers and taking reasonable and proportionate action in these challenging circumstances. In the Northern Territory, most medical and allied health providers are now treating injured workers face-to-face, so this includes surgical procedures. However, there are some treatments and surgical requirements that are not conducted in the Northern Territory, therefore requiring a worker to travel interstate. Many of these medical interventions have been placed on hold due to border closures, requirements to mandatory quarantine, or the general high risk of exposure to the virus, which creates additional apprehension and stress, not just on the worker, but on their families, but also on the workplace. In the case of NT workers who have relocated interstate and are in a heavily restricted area, their treatment requirements have been placed on hold, with the only interaction being through the telehealth platform or the like. Again, placing additional stresses on that worker and potentially having an adverse effect on their mental health and their recovery. As insurers remain in operation, it is crucial for claims managers to be mindful of these circumstances, ensuring the worker is being supported in the right way for that person. In regards to post-operative reviews that would normally require a worker to travel interstate, many specialists have been using the telehealth service to assist in conducting these types of reviews with the assistance of qualified allied health professionals such as physiotherapists. For independent medical assessments, known as IMEs, a majority of the consulting specialists are fly-in. Due to the height of COVID in the Territory, many of these specialists were using the telehealth services to conduct their assessments in the same form as the post-operative reviews. Again, the allied health professionals, such as the physiotherapists, were required to conduct the physical aspect of the assessment for workers within physical injuries. As the restrictions have eased in the Northern Territory and the opening of borders, there has been an increase of specialists now flying back into the Northern Territory to conduct their assessments face-to-face. The COVID pandemic has shown that medical professions, like many others, that there are other ways to conduct business. which has ensured injured workers continue to have access to their treatment providers. The negative impact on recovery is reduced. Under the Return to Work Act, a worker who sustains an injury at work is entitled to family counselling. This counselling is for the worker and a member of the worker's immediate family. This is to assist the worker or their family member to cope with the psychological impact of the injury sustained by the worker's injury. It can be provided individually to the worker or to a group of the worker's immediate family. The counselling must be provided by a medical practitioner, a registered psychologist, social worker or a counsellor. The cost for family counselling is capped at 150% under the legislation, and this is 150% of the average weekly earnings at the time the costs are incurred. A worker and their family who attends for family counselling does not require pre-approval from the insurer. It's simply a conversation you would have with your GP if it's a requirement. So what is covered under COVID-19 claim? So having an accepted claim for COVID-19 does not alter a worker's entitlements under the Act from any other accepted claim for an injury or disease. Entitlements for workers with an accepted workers' compensation claim under the Act include weekly compensation for loss of wages. Workers are entitled to receive their normal weekly earnings for the first 26 weeks of total or partial incapacity, less any amount they actually earn. If after the first 26 weeks workers are still incapacitated, they will normally be paid at 75% of their loss of earning capacity. There are also minimum and maximum provisions that apply. So other workers' compensation entitlements workers may be eligible for include reasonable cost for medical, surgical and rehabilitation treatment, which is your physiotherapy, chiropractic treatment, hospitalisation and hospital treatment, pharmaceutical expenses, travel or transportation costs to attend treatment or hospitalisation. Now this includes a kilometre rate if using your own vehicle. Upskilling or training for a different career if the injury prohibits working in a pre-injury position. Payment for a permanent impairment. So the list I've just mentioned isn't exhaustive. Again, it's based on the needs of individual workers as they are all different. So what happens when I'm fit to return to work? Returning to work is a dedicated process that requires the worker and the employer to have a clear understanding on what the return to work goal is, and taking into consideration the worker's medical restrictions and capacity to undertake duties. COVID-19 may make the return to work process that little more challenging if a business is closed or is operating at partial capacity. However, regardless of the impacts of COVID-19, an employer's obligation remains, and that is to assist an injured worker to return to work. When a worker who has been fully incapacitated for work is then certified to return to work in some form of capacity, the employer is obligated to assist the worker with suitable duties in the workplace. If the suitable duties are not available, such in the case of COVID-19 has forced a business to operate at reduced capacity or unable to reopen with staff, then the employer must assist the worker with the support of the insurer to find suitable alternative work. Alternative work can be in the form of modified duties, a new position within the business, or even work with a different employer altogether. To support this process, a vocational rehabilitation provider may be involved to assist in sourcing alternative employment with a new employer, or they can review the workplace to ascertain if the worker could undertake any alternative duties with the same employer, as this is always the best case scenario for both the worker and the employer. During the interim, when work is being arranged for alternative work, the worker is to be paid at their workers' compensation rate of pay. This includes the host employment activities the worker undertakes with a different employer. This arrangement is a short-term arrangement that assists the worker to increase capacity until they are fit to return to their normal workplace and or to other duties. Everyone involved with the worker's return to work, the doctor, the worker, the employer, the vocational rehabilitation provider and the insurer's case manager should communicate and work together to achieve a successful outcome. Studies have shown that staying at or returning to work is an important part of workers' recovery. So Anti-WorkSafe has developed a number of videos to support workers, employers or other stakeholders in workers' compensation, and we will now show a short video that will assist workers in regards to the return to work program.
Welcome to the Northern Territory Workers' Compensation Scheme. This short presentation will assist you with how to return back to work. We'll explain the return to work process and what help is available to you. If you haven't yet lodged a claim, watch our video Making a Claim. It outlines the steps and what is involved. Working is good for our health and well-being. When you've been injured at work, an early and successful return to work will help you get back to normal life. You are the most important person to manage your injury and recovery. Focus on what you can do rather than what you can't. Speak with your doctor about the kind of work and activities that can assist your recovery. Keep your employer informed and stay in touch with your workmates. Be involved in planning your return to work. Everyone involved with a worker's return to work activities, the doctor, the worker, the employer, the vocational rehabilitation provider and the insurer's case manager should communicate and work together to achieve a successful outcome. To achieve the best return to work outcome, there may be times when your rehabilitation provider or employer may need to speak to your doctor. You are entitled to privacy during the consultation with your doctor. Your rehabilitation provider or employer may organise back-to-back appointments or dovetail into a long consultation with the doctor. Most of your return to work activities will be based on the medical certificates your doctor issues, a fitness for work medical certificate. You may not be 100% recovered, but working together with your doctor, employer and the insurer will ensure that you get the help you need to return to work. Once your doctor issues a fitness for work medical certificate, you and your employer can start to plan this process. With your employer and doctor, you need to discuss your usual job, what alternative tasks you can perform, your working hours, and what supervision or other support you may need. If you are unable to return to your usual work within 28 days, your employer must give you a proposal in writing for a return to work plan. The plan will be prepared by your employer, sometimes with help from the insurer, and reflect any restrictions on your fitness for work medical certificate from your doctor. It's important that your return to work goal is identified early so everyone can work towards it. The return to work plan sets out how, when, where and in what way you will return to work. In most cases, you'll return to your usual job. However, an injury may keep you away from your pre-injury position for weeks or even months, or you may not be able to return to your usual job at all. If this is the case, your employer may be able to provide you an alternative job permanently, or the insurer can assist you with finding a new job with a new employer. If your employer has trouble finding suitable duties, you may need to do a work trial or retraining, or if there are other issues stopping your return to work, a vocational rehabilitation provider may be appointed by the insurer to help you and your employer. Case conferences can also be held to bring together everyone involved in your claim. The claims manager appointed by the insurer will coordinate the management of your claim. If a return to work plan is in place, you're expected to attend work and perform the agreed duties set out in it. Otherwise, your compensation entitlements may be affected. If you're having difficulties following the plan, speak with your treating doctor, the vocational rehabilitation provider, your employer or insurer so amendments can be made if necessary. You're not alone in this process. Further information and help are available. Watch our series of videos for more information. Further information and help are available. If you have any questions, contact your claims manager, treating doctor, vocational rehabilitation provider or NT WorkSafe who can assist you.
NT-WorkSafe have developed, bear with the echoes, have developed a number of frequently asked questions that aims to help workers with general questions regarding COVID-19 in relation to workers' compensation. These are located on our website under the Workers' Compensation tab. So some of the more common questions that we have been asked during, the height of COVID is, I've been told by my employer to undergo testing for COVID-19 and stay at home, as I have symptoms such as a cough and a fever. Will workers' compensation cover my wages while I'm self-isolating until my test results come back? Workers' compensation would not cover your wages during self-isolation unless you are subsequently diagnosed with COVID-19 and can establish that your employment was the real, proximate or effective cause of you contracting the virus. Self-isolation does not mean a person is suffering from an injury or a disease. Each claim for COVID-19 would need to be considered on its individual merits, taking into account individual circumstances and evidence. Another common question has been, what if information do I need to provide to lodge a claim for COVID? As with all workers' compensation claims, a claim will need to be lodged with your employer. For workers to lodge a claim for COVID-19, the insurer will require completed workers' compensation claim form, a current medical certificate of capacity, this is issued by your GP, that provides the medical assessment and the diagnosis for COVID, evidence to demonstrate that the COVID-19 exposure occurred within the work environment and that the employment was the real, proximate or effective cause of you contracting the virus. Further queries we've received. I have a current workers' compensation claim. I live remotely and am worried about exposure to COVID-19 while travelling long distances for medical appointments. Do I need to attend these appointments? So all insurers and self-insurers will give careful consideration to the potential impacts of COVID-19 on workers and will monitor the situation. The Act requires a worker to undertake reasonable treatment and training or assessment. However, insurers and self-insurers have strong contingency plans in place that include making alternate arrangements to assist injured workers and taking reasonable and proportionate action in these challenging times. It is recommended that you do contact your claims manager if you have a claim to discuss your concerns relating to travel and attending appointments. Another question we've received is, I have returned to work on full duties. However, I'm still receiving medical and rehabilitation treatment for my claim. I have COVID-19 symptoms and have been told not to attend work. Will I be entitled to weekly compensation payments? If you have returned to full duties and are required to self-isolate, then your normal leave requirements will need to be utilised in this situation. Having to self-isolate due to COVID-19 would not be incapacity for work that your injury materially contributed to and would therefore not be considered as part of your existing claim. Workers' compensation wage payments are not paid for personal illness unrelated to a worker's claim. So if you've been instructed by your employer to work from home and you meet the definition of worker and are injured while working from home, you may be entitled to claim for workers' compensation. Whilst a worker is not attending their normal business premises, the home of a worker would be considered a workplace under the Return to Work Act. So what is considered a workplace injury at home? A workplace injury is an injury that a worker sustains out of or in the course of employment, such as, but it's not limited to the following: repetitive strain injuries or other musculoskeletal injuries. This may be caused for many reasons, such as the incorrect workstation setup, not taking breaks, or working longer hours. There are psychological injuries, such as anxiety and depression. This may be caused for many reasons, such as unsupported working arrangements, incorrect resourcing, or the isolation of having limited or no contact with peers and supervisors. The most unfortunate aspect of over 2.5 million Australians working full-time from home is that many will experience mental health consequences that may not have been at risk if it wasn't for COVID-19. Other injuries that may occur could be injuries whilst on a recess break, such as making a coffee and burning yourself, or simply tripping over Lego blocks on the floor and injuring your arms. So that would be your trips and falls. Employers still have a responsibility to ensure a worker has an ergonomic work desk and chair, and the hazards and risks around the workstation are minimised, such as your lighting. In order to minimise the risk of sustaining a physical injury, employers prior to directing a worker to work from home should have assessed the suitability of the workstation environment, either in person or via video call, conducted a risk assessment or provide the worker with a workstation self-assessment checklist. When it comes to workers' mental health, when working from home, employers are required to provide clear instructions to workers on how to perform the duties in a safe manner with regards to the mental health. Understanding how to report any issues being experienced with mental health. Provide workers with access to communicate with colleagues and bosses through video calling and other messaging platforms. If a worker sustains an injury working from home, they can lodge a workers' compensation claim on their employer, who will have to provide to their insurer within 3 working days. The insurer will make a determination on the liability with the information they are provided at the time the decision is due. If you or someone you know is having a tough time and need to talk to someone, there are a number of helplines and services that are available throughout Australia, such as what we have on our screen today. So mediation conferences. NT WorkSafe is following the government advice provided on the Northern Territory Government Coronavirus website and have received our COVID safety plan commitment statement. Our team are committed in delivering a safe environment for all people attending our office for mediation conferences and all other businesses that we conduct face-to-face. Currently, mediation services are continuing, and when an application for mediation is received, workers will receive any further updates from the mediation coordinator. If a worker is following government protocols and are currently in self-isolation or have concerns for their health due to underlying conditions, workers are asked to make this known in the application for mediation. Workers will be able to discuss possible alternative arrangements with the mediator when they are appointed. This could possibly be by teleconference. As part of our COVID safety plan, NT WorkSafe have conditions of entry into our office. We ask that persons does not enter if the following applies: feeling unwell with any cold or flu-like symptoms, have been in contact with a person known to have COVID-19, have recently returned from interstate or overseas within 14 days, have been in contact with someone who has recently returned from overseas within 14 days. It is strongly advised that if any of these apply to anyone attending our office, that this information is provided to the mediator prior to attending, as alternative arrangements, as I've just mentioned, can occur, such as our teleconferencing. For further information on mediations, please refer to the NT WorkSafe website. So as shown in our videos before, we do have a number of videos that will provide information and a greater understanding on workers' compensation. You may be interested in the range of the short videos for stakeholders such as making a claim, returning to work, entitlements, dispute resolution, case conferences, information on rehabilitation providers, and there's also information for visa workers. We also have additional videos for Aboriginal workers. This is provided in English, but also in language as well. Anti-WorkSafe are working closely with other departments such as health and councils to ensure knowledge is out there for both injured workers and employers on entitlements and obligations throughout the Northern Territory. Anti-WorkSafe will continue to strive to promote and educate all stakeholders within the scheme. I will now open up the floor for questions. Do you have any questions? Yeah. 26 weeks. So the question at the museum is in regards to the 75%, which is our 26-week capping. Once they've dropped to 75%, is the employer obligated to top that up? The answer is no, they're not. It is actually legislated that it is a drop in pay. And some employers may top it up, but I guess the incentive is for someone to return to work if they possibly can in some form. And that's where we've got provisions in place for the Act where if somebody, because of the nature of their injury, they can't return to the same workplace or the same role, then alternative work is put in place and measures. So they will be paid at their workers' comp rate at 75%, less of course whatever they can physically earn as well, but there's no obligation for the employer to top them up. Yeah. So do we have any more questions? Okay, well then I'd like to thank you all for taking the time to attend today. If you'd like any further information in regards to today's presentation, or if you happen to think of a question after the presentation, please email us or give us a call. All the information is on our website, and we're more than happy to assist you where we can. So thank you again and have a great day. Bye.